Hello students, this is Supriya Mogle, Assistant Professor of Center for Distance Education, Shivaji University, Kolhapur. I am here to discuss about Board of Directors, which is one of the important topic of company law. And in this video, we are going to see, the roles or the powers of Board of Directors, how many members it should have in the company, or what are their powers, what are their restrictions, or who will appoint the directors, etc. Various contents included in this video. So let's start. Okay, so as we have seen in the previous video, there are board meetings, there are directors in the company who takes decisions, who takes responsibilities. So we can say if company is considered as an artificial person, the board of director is the brain. Okay, so without board of director, company is incomplete. So let's see about in detail. Okay, so a person is having a position of director. He is called director of the company. Suppose any person with different name but performs all the functions of director, then also he is treated as a director as per the law. So in short, a person having control over the direction, control, and overall management of the company's affair, he is called a director. Then, how many members should be there in the board of directors? So, the minimum limit of directors in a company is laid down by the Companies Act. So, if there is a public company, then at least three members should be there. And in the private company, at least two members should be there in the board of directors. A company or a public company having paid up capital of 5 crore, okay, paid up capital of rupees 5 crore or more, and which has 1000 or more small shareholders shall have at least one director. So remember this, it can be asked in the MCQs. Okay, so the minimum limit of directors, if it is a public company, it should be at least 3. If it is a private company, it should be at least two members of the directors. And suppose a public company which has a paid up capital of rupees 5 crore or more, and it has small shareholders, but they are in the number of 1000 or more, then it should have at least one director. Okay, the next point is appointment of directors, how they appoint the directors. Okay, first directors means generally promoters becomes the first directors. Okay, first directors are named in the article of the company. Then appointment by the company, the shareholders appoint at least two-third of the total number of directors. Means who are the shareholders of the company, they can appoint the director. How many? Two-third of the total number of directors. For example, a company has, 10, they want to appoint 10 directors in the company. Then out of which two-third will be appointed by the shareholders. Then appointment by directors, so the directors who are appointed already, they can appoint other directors like additional directors or alternate director, or suppose any director resigns, or suppose due to his death, they can appoint other director. Okay, then appointment by third parties, suppose company which has taken advanced loan, and that creditors or banking company can nominate the director. Okay, so the company which from which you have taken loans, that company or that creditors have the power to nominate the director. Okay, just remember, but number of such nominees should not exceed one third of total number of directors. Okay, so only one third of total number of directors can be nominated by the creditors or the banking company from which you have taken the advance loan. Then fifth one is appointment by the proportional representations. That means there is a principle of proportional representation, okay, and the article of the company which is declared in a law, so may provide for the appointment of not less than two-thirds of the total directors of the public company. So the article of the company can give the notification, they have the power for nomination of the total directors, but it should be two-thirds of the total directors of the public company, okay. Appointment by central government, so central government has also a power to appoint directors on the board of company if it is necessary to safeguard the interest of the shareholders or public interest, but these appointments are done only on the recommendation of the tribunal, okay. So tribunal means a court of justice. If they recommend to do the appointment to the central government, then only central government has a power to appoint the director, okay. So these are the types of appointments of the directors. Next point is powers and restrictions. So there are some powers to the higher authority and some restrictions on the appointment of the directors. We'll see. So powers to be exercised at board meeting, okay. As we have seen, there are various types of meetings held in the company. So what type of decisions taken in that particular meetings we are going to see in the board meeting, okay. Powers to be exercised at the board meeting as per the companies act or as per the memorandum or article of association, they make call on shares, okay. They issue the debentures, borrow money through public deposits or invest company fund or making loans, so etc can be done through board of directors. In short, what financial related decisions will be taken in the board meeting, okay. Next is power to be exercised in the general meeting, okay. So what about the general meeting? So they can sell, lease or dispose related decisions, debt related decisions, company needs some time to repay that, or decisions related with the compensation or borrowing money. If you want to have some social responsibility like contributing to the charitable or other funds not directly related to the company, so etc, selling, leasing, disposing or uh, repaying or compensation, borrowing money or contributing to charitable trust, etc, exercises are uh, included in the general meeting. Then next point is restrictions on appointment of directors, okay. So what are the restrictions while appointing one director, okay. So a person to be appointed as a director will be restricted from such appointment unless he has, okay. Now first understand the meaning of this sentence, restricted from such appointed unless he has. That means what, a person to be appointed as a director should be, okay, should be signed and submitted a written consent with the registrar. That means that person should take permission of the registered in writing, okay. Then next is he should be purchased qualification shares or agreed to pay for such shares in the memorandum of the company. That means what, a particular shares should be purchased by that person or he should agree to pay the shares in the memorandum. Then third is made and filed with the registrar an affidavit stating that his qualification shares are registered in his name. So he has to have an affidavit which states that his shares are registered now with the permission of registrar. So these are some restrictions on the appointment of a director. Next is restriction on number of directorship, okay. So what are the restrictions? Like a person cannot become a director or cannot hold the office of director of more than 20 companies at the same time. Okay, so more than 20 companies you cannot become a director. Okay, then next is operation and mismanagement. Okay, so what is the meaning of these two concepts we are going to see? Introduction. Okay, when already we have studied the meetings and proceedings, etc., and we saw the decisions of the companies are taken on the basis of majority, like majority. Okay, management of a company based on the rule of majority, and the principle that will of the majority must bind the minority is known as principle of majority rule. But under some circumstances this principle of majority rule may cause harm to the interest of the minority of the company. Okay, suppose there are 10 members in the in the board of directors, and 7 members are convincing one decision and 3 members are not agreed with the decisions. Their view or their idea or their point of view will be different. Okay, but because of the majority, the sevens, what they are saying are accepted. But what about the minority? Their idea or their shares have to be considered by the company. Okay, they may feel that they are ignored, or their they don't have that right to talk about it. So it is called principle of minority rule. That means you are going to listen their decisions or listen their opinion, and then you can take a decision. So hence, to protect the interest of the minority or to avoid the mismanagement, suppose 7 members are having one decisions, and on basis of majority you are going to have some management regarding the decision, and suppose their decision is somewhat wrong, and the minority means 3 people are saying a right thing, but their concepts or their shares are ignored. So there will have consequences. You will have to face some mismanagement. So to protect that interest of minority or to avoid that mismanagement of the company affairs, due to provisions have to be made under the law, and that's why section 397 is prevention of operation and section 398 is prevention of mismanagement, explained in the Companies Act 1956, which are framed to protect the interest of minority of the company. So this is the short and simple concept, operation and mismanagement. Then prevention of operation. Now how you are going to prevent these minority? Okay, so section 397 states that requisite number of members of a company can complain to the tribunal. Okay, so whichever the minority persons, they can complain to the tribunal. Tribunal means what? The court of justice. Now requisite number, how many members should be there? It means not less than 100 members or not less than 1/10 of the total number of members, whichever is less. Now tribunal, they are going to complain to the court of justice. Court of justice will take a decision, will think about it, will discuss about it, and if they satisfy that their complaint is true and they are valid, and their views and their opinion should be considered, then tribunal will pass an order. It may think fit. If they think it is valid, if they think it is fit to the end, then they will give the relief to the minority. So this is the process of prevention of operation. Then what are the powers of tribunal? As I have said you, the tribunal, that is court of justice, have to take some decisions. So what are their powers? First is they can regulate company affairs in the futures. they can control, they can regulate on the company affairs. Okay, then in case of purchase of share by any members or by any company itself, suppose there is some issue related with the shares, if there is some disputes related with the company or the members related with the shares, then tribunal have that power to take a decisions. Or cancelling or modifying an agreement between the company or a company and its management, means they want to some cancel some agreements, or they want to have some changes in the agreement, then the tribunal have that authority to take the decisions or to pass the order regarding it. Okay, the tribunal, read this last paragraph, the tribunal also has the power to prevent or stop any change in the board of directors if tribunal feels that such change will affect the management of the company and affairs of the company must be mismanaged. So accept these things if the tribunal thinks that there should have some modification in the management, or they think that it is not going correct or it is mismanaged, then they have some power to regulate that affairs to prevent that change in the board of directors. So these are the powers of tribunals. Then powers of central government. Central government has also some authority, some power. So what are they? They also can appoint a director to the board of directors. Okay. Then they can make such appointments only after the tribunal has made necessary injury in the complaint about the operation and mismanagement. As we have seen the operation and mismanagement, that means we are going to protect the minority rule. Then if there is any complaint from the minority person, then on the basis of that central government can appoint. Okay, then central government may appoint such members of persons on the board of directors as tribunal may recommend or specify. If tribunal recommend to the central government that that some of the members should be appointed, then central government may appoint them. The directors so appointed by the central government need not purchase qualification shares. Okay, as we have seen the restrictions on the appointment of director, he should purchase some shares of the company, then only he can become a director. But a person who is appointed directly by the central government need not purchase these type of shares. Such share shall be appointed for the period, such a director shall be appointed for the period not more than 3 years on one occasion, and can be removed or replaced only by the central government. Okay, a person is appointed, a director is appointed by central government, but he will be appointed not more than 3 years. Okay, and if a company wants to remove or wants to replace any director, then they cannot do that. Only central government can remove that director or replace that director. So these are the powers of central government. So here I complete my video. I hope you understood the concept. The we have seen various concepts like board of directors, the members, and their powers, their restrictions, operation, what is mismanagement, what is powers of tribunal, central government, etc. So I hope you understood the concept. If you have any doubt regarding it, you can message me, you can comment. Okay, thank you.